evening. Good evening, ladies and gentlemen. My name is Chloe Coleman, and on behalf of the Board of Student Advisors and Dean Minow, I want to welcome you to the final round of the Ames Moot Court Competition. The case before the court tonight, McBride v. United States, was written by Tajinder Singh, Harvard Law School class of 2008. Petitioner McBride is a blogger convicted of hacking into the Ames City Exchange to display the message that taxpayers demand a refund or else on the trading floor's screens and tickers. The case presents two questions. First, whether the good faith exception to the exclusionary rule applies to evidence obtained pursuant to a search warrant when the evidence supporting the issuance of the warrant was itself obtained during a warrantless search that violated the Fourth Amendment. Second, whether under 18 U.S.C. section 3583D, which provides that supervised release conditions can involve no greater deprivation of liberty than is reasonably necessary to achieve the sentencing goals of deterrence, protecting the public, and rehabilitation, a district court may issue a special condition of supervised release, barring an offender from all use of computers and the internet. Petitioner Kermit McBride is represented by the Honorable William Wayne Justice Memorial Team. Jason Harrow, Philip Mayer, Jason Murray, Amanda Rice, Zachary Schaff, and Yujing Yu. Jason Harrow and Philip Mayer will be making oral arguments this evening on behalf of the team. The United States is represented by the Honorable Griffin Bell Memorial Team. Dustin Cho, David Denton, Taylor Hathaway Zepeda, Luke McLeod, Lindsay C., and Benjamin Snyder. David Denton and Lindsay C. will be making oral arguments this evening on behalf of the team. The Honorable John G. Roberts, Jr., Chief Justice of the United States Supreme Court, will preside as Chief Justice of this final round argument. Joining him will be the Honorable Diana Murphy of the United States Court of Appeals for the Eighth Circuit and the Honorable Julia Smith Gibbons of the United States Court of Appeals for the Sixth Circuit. No photography of any kind is allowed at any point before, during, or after the argument. We also ask that you please remain seated while oralists are speaking, and please turn off all cell phones at this time. Finally, please hold your applause until all oralists have finished speaking, and remember that the petitioner will make rebuttal arguments after the respondent has spoken. With that, best of luck to both teams, and enjoy the argument.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to come forward and keep your attention, for the court is now sitting. God save the United States and this honorable court. You may be seated.
We'll hear argument this evening in Case 10-135, McBride versus the United States. Counsel for petitioner. You proceed.
Mr. Chief Justice, and may it please the court. My name is Philip Mayer. I'll be representing the petitioner Kermit McBride, and I'll be addressing the good faith exception Fourth Amendment issue. Your Honors, as this court stated in Payton versus United States, warrantless invasions of the home are the chief evil against which the Fourth Amendment, and thus the exclusionary rule, is directed. The simple question before this court is whether to deter or reward future officers like Ames police officer Ralph Fredrickson. Officer Fredrickson not only engaged in what the district court found to be a plainly unconstitutional search of the petitioner's home, he then subsequently misled the courts and his colleagues, thereby inducing a second unlawful search of the home. The good faith exception has never applied and should never apply in such situations. More specifically, we ask that this court clarify that the good faith exception never applies when one officer relies upon the tainted fruit of a fellow officer's failure to observe constitutional norms.
What would you have had Officer Broad do in this case?
Your Honor, Officer Broad, we don't question his good faith. Certainly it would have been more ideal had he questioned Officer Fredrickson and found out a little bit more of the details, but we believe that the central question is that Officer Fredrickson's conduct was deterrable, and therefore that the good faith exception, as this court has always analyzed the question, looks to whether or not the underlying conduct, in this case Officer Fredrickson's conduct, was deterrable. So we can track that through all of the good faith exception cases that this court has decided. In Leon, there was a third party.
But Officer Fredrickson wasn't involved. He wasn't in the department involved with the computer search. He wasn't investigating that crime. He doesn't have much invested in that.
No,
so
that's
is
correct.
He going to be how is he going to be deterred by an impediment put in the prosecution of that crime?
That's correct, Your Honor. He wasn't involved actively in the investigation, except in the key thing which he did do, which was provide information in the warrant affidavit. And the collective knowledge doctrine is specifically calls upon such situations to be imputed to all of the officers involved in applying for a warrant. This court
That's
clarified.
That's not what we held in Herring.
Well, in Herring, this court specifically stated that it was necessary to look at the conduct of all of the parties involved, Your Honor, and to analyze whether any of them engaged in deterrable misconduct.
Don't you have to also balance against the cost of what exclusion would mean to the government?
I'm sorry, Your Honor, I couldn't hear
You
your
have
question.
to balance the conduct of Fredrickson against the cost of exclusion of the evidence?
That's of course right, Your Honor. This court has always instructed that suppression is a harsh remedy, and so there must be a balance. But in this case, Officer Fredrickson's conduct was core deterrable Fourth Amendment violation. It was a warrantless search of citizens' home.
Doesn't it make a difference here that the crime for which Mr. McBride was prosecuted didn't occur till way after, a couple of weeks after Officer Fredrickson was in the home? His search for evidence had nothing to do with this crime whatever.
That is the government's suggestion, Your Honor. But there's two ways in which Officer Fredrickson's conduct nonetheless could have been deterred. The first is training, and the second is concerns about pretext. With respect to training, he could have been taught that this was a clearly unconstitutional
You don't
search.
think that police departments engage in this kind of training already? You know, if the exclusionary rule hasn't had that much impact, what impact would it ever have?
Well, what we're concerned about, Your Honor, is that he may not have been adequately trained on exigency circumstances, because the situation suggests that he was not. The only evidence before him was an open door and a neighborhood reported.
Seems a lot more likely that he just made a mistake than that his training was inadequate.
It's entirely possible that he made a mistake, or his training may have been adequate, or he may have been in the home for reasons besides the ones he stated. In fact, the district...
Isn't it the interest of the public to have people investigating possible burglaries?
Of course, Your Honor, but only when the requirements for the exigency circumstance have actually been met. The Fourth Amendment allows officers to enter homes in case of exigency, but where those circumstances have not been met, that's the balance that the Fourth Amendment strikes.
He had the tip, and he went and responded, and the door was ajar. Was his fault that he snooped around too long? Was that the extent of why the evidence should be excluded?
Well, the problem is that he didn't have enough evidence amounting to probable cause, which is why the district court found his search plainly unconstitutional. In addition,
you don't need probable cause if you have exigent circumstances, do you?
Under this court's holding in Kirk versus Louisiana, which is a per curiam decision from 2003, I believe, Your Honor, the court held that you need probable cause and an exigent circumstance. So there has to be probable cause that there's something going on, and there also has to be exigency that calls for the urgent need to enter the home without going through the normal warrant process.
Why are we talking so much about Fredrickson? He wasn't the one who got the search warrant. That was Broad. And all this bad stuff that Fredrickson did, Broad didn't know anything about it at all. That's really the point of contact. He's the one who got the search warrant. He's the person you want to deter if he's doing anything wrong. He didn't do anything wrong at all.
We agree that that Agent Broad's conduct was not sufficiently reckless or negligent to require suppression. But the reason that we think the focus is on Officer Fredrickson is precisely because of what this court has said in its previous good faith exception cases. In Leon, in footnote 24, the court explained that references to officer throughout the opinion should not be read too narrowly, but that it was necessary to consider the reasonableness not only of officers who eventually executed a warrant, that's Agent Broad, but also of officers who originally obtained it or who provided information material to the probable cause determination.
What was the relationship between the two officers in Leon? Were they in the same department?
Your Honor, there weren't multiple officers at stake, I don't believe, in Leon. Or if there were, then the relationship between the officers was not at issue. We understand footnote 24 to be explaining that there's no loophole for law enforcement agencies to do exactly what happened here, which is where one officer has viewed evidence.
Well, I understand the idea if you have two officers in the same department attributing the conduct of one to the other. But there are a lot of different departments and agencies, they cooperate and interact. It seems a bit much to say that Sheriff so-and-so from a particular county's conduct is attributed to Agent so-and-so from the FBI. That's two totally different departments.
Well, that's exactly the sort of situation, Your Honor, that the court confronted in Elkins versus United States, in which this court rejected the silver platter doctrine, which would have which formerly treated the exclusionary rule differently, depending on whether or not the officers were from the same department or were moving the evidence between state and federal levels.
But in Herring, we did not hold the agency executing the warrant responsible for the errors made by the officers or the folks in the other county, correct?
Well, in fact, Justice Gibbons, we think that that's exactly what the court did, which is not to say that the agency was held responsible, but the court's opinion specifically examined whether the other county who had committed the negligent error of record keeping, whether that county had engaged in deterrable conduct, finding that it had not. Finding that it had not.
I just have my mouth open. I'm not ready to speak yet. It's coming.
Anytime. Finding that it had not.
Mr. Meyer, could
yes.
I ask you, why isn't this like Leon? Because they did go to get a warrant, and the magistrate judge could have asked and inquired, but didn't. So why isn't it admissible under Leon?
The reason this isn't simply a Leon case is a point that the government misses and we want to emphasize, which is that magistrates are not ideally equipped to determine the constitutionality of a prior search. This court has explained in Franks versus Delaware that magistrate proceedings are hasty and ex parte, and indeed, although the magistrate in this case was indeed a judge, magistrates do not have to be even lawyers or judicial officers of that sort. So it's not an appropriate setting in which to determine the complex doctrinal question of whether or not there's been a prior Fourth Amendment violation.
How far are you going to spin this out? I mean, let's say Broad took the information he got from Fredrickson and gave it, he's in the FBI, he gave it to somebody in the Bureau of Alcohol, Tobacco, and Firearms, and that person gave it to someone in the Secret Service, and that person got a search warrant and executed it. Does Fredrickson's mistake with respect to the Fourth Amendment carry on all through that chain? Fredrickson finds out, well, I had no, 2 years later that the Secret Service has executed a search warrant that depended on what he did. Is he going to be deterred when that evidence is excluded under your theory?
Well, again, the question is not how far the evidence might travel. To the extent that happened...
Well, that actually is my question.
It certainly is. And so let me address that squarely. Certainly, the information, if it traveled in some particularly attenuated and circuitous way, might be admissible, depending on the facts of the case. It's not the case before the court here. But that analysis would have to focus on whether or not there was anything more going on than just passing the information from one person to the next until it got to the useful person. Because the primary idea is to make sure that an officer does not have an understanding that if he or she conducts an unlawful search, that there's a way to launder that to the appropriate authorities. So a process that involved simply handing it around in order to get around a rule would certainly not be okay.
Well, it seems to me that the natural consequence of your argument is that officers like Officer Broad and the others down the road would have to have imposed upon them a duty of inquiry about the information previously obtained. And you've sort of disavowed that that's where you're taking us, but I don't see how to avoid that. How can we avoid that being the practical outcome of accepting your argument?
Well, Your Honor, we don't think it would be any sort of constitutional duty, but certainly a future officer would be the point of the collective knowledge doctrine is it gives a future officer a choice to either inquire further or else to accept the evidence as presented and take the risk that it might be suppressible. And the reason is because of this court's poisonous fruit doctrine. And the poisonous fruit doctrine has always held that when there's tainted evidence, that officers can't benefit from that later unless there's been sufficient attenuation or an independent source or one of the narrow exceptions.
Sort of turns the lead.
Agent Broad is in this very specialized area of cybercrime, this forensic department. Aren't those agents going to have to rely on other people to come up with evidence from the outside world because they're so specialized? And they had done, in this case, their forensic examination and narrowed it down to 2 million people.
Certainly, Justice Murphy, cybercrime investigators may need to rely on tips from other officers, but that's all the more reason why it's important that those other officers know that their conduct must be constitutional, or else they face the risk of suppression. If there's no further questions on our primary argument, I'd like to I see I have a few moments left to address our argument in the alternative, Your Honors, which is, as I mentioned, we don't think that magistrates are the appropriate persons to adjudicate questions of whether or not a prior search has been unconstitutional.
Well, who's supposed to do adjudication if not a judicial officer?
Well, we think it should happen in an adversarial proceeding with counsel during a normal suppression hearing in front of the district court, but not during the hasty ex parte proceedings that this court has described in its previous holdings.
Well, certainly that's not a full-blown adversarial proceeding, but isn't the magistrate in a position to make the judgment call?
The magistrate may be, Your Honor. We don't think that that's the right thing to focus on, but if you do wish to focus on it, then we want to emphasize that in this case, in which Officer Fredrickson did everything in his power to make sure that the magistrate did not have before her the information necessary to adjudicate a prior.
Officer Fredrickson made no material misstatements. I mean, a simple inquiry prior to issuing the warrant would have sufficed to have determined the lack of probable cause.
But, Your Honor, precisely because magistrates aren't normally called upon to adjudicate questions of
Well, they sure are called upon to decide whether probable cause exists, aren't they?
Oh, that's absolutely right, and that's precisely the point. What a magistrate judge would normally be expecting is to make the common sense judgment of whether or not probable cause exists based on the sum of the evidence presented before her. If she's being called upon to do abnormal task, which in this case adjudicating the constitutionality of a prior search is, then the government should, if it wants to use the good faith exception, at the very least be required to explain to the district court, or excuse me, to the magistrate that there's an issue that requires adjudication.
But
otherwise,
you think it's so hard for the magistrate to do this, but it's exactly the burden you're putting on Broad. He has to interrogate Fredrickson or any officer on whom he relies to find out if it's a constitutional search before he can rely on the material.
Well, Your Honor, the only burden we're putting on Broad is the same burden that the Fourth Amendment already required, which is that if he's relying on tainted evidence, he needs to be aware of that and not use it.
How does he make himself aware of that? The officer comes in, says, I was conducting a search on regular police business. Look at what I found. So what's Broad supposed to do?
Certainly the more prudent thing for Broad to have done in this situation would have been to ask a few questions. And we do think that a few simple questions...
What's the first question you'd ask?
What were you doing in a citizen's home in the back bedroom of someone about to commit a crime?
The first thing he's going to say, it's 12 days. He said, it was 12 days ago. I've had 38 burglary cases since then. I don't know.
I mean, well, certainly this happened only a couple of weeks after after Officer Fredrickson had been in the home, and certainly he remembered the details well enough to have sworn them out in the warrant affidavit. So we think it's likely that he probably would have remembered the details of this particular search, especially because it's an exigent warrantless search of a home, which officers should know is presumptively unconstitutional.
Agent Broad, at this point, when he gets his call, he's concerned about all of the loss there's been because of this incident and the fear that it will happen again. And so he's trying to prevent that from happening. And that's his major concern, isn't it?
Your Honor, I see that my time has expired.
can
May I
answer
briefly
that
respond? Thank you. Certainly that's going to be his main concern, to try to pursue this lead, but it shouldn't cost him too much time or we think any rancor with the local police to simply establish the basic facts of what Officer Fredrickson was doing there. There were a few simple facts here: an open door and a neighbor's call. That would have been enough to put Agent Broad on alert.
Thank you, counsel. Mr. Harrow?
Mr. Chief Justice, and may it please the court, good evening. My name is Jason Harrow, and I represent the petitioner. I'll be arguing tonight on the second issue regarding the computer and internet ban. Your Honors, the core of this issue is Section 3583. Subsection D1 of that provision gives district judges discretion to impose special conditions of supervised release when they reasonably relate to three statutory goals: deterrence, protection of the public, and vocational and educational needs. But the very next line, subsection D2, importantly cabins and qualifies that discretion by providing that such special conditions must, quote, involve no greater deprivation of liberty than is reasonably necessary to fulfill those.
Are they supposed to protect the public too?
Yes, Your Honor, that's absolutely correct. There's a balance that Congress struck. On the one hand, a district judge is allowed to craft conditions that serve the goals of deterrence and protection of the public while also helping to rehabilitate a defender. But on the other hand, in the very next line, Congress told district judges to carefully tailor supervised release restrictions and consider the impact on the liberty of a defendant.
They didn't tell them to carefully tailor, did they?
They used the phrase...
That's your deduction from what they said, right?
That's correct, Your Honor. This court has not construed this provision of Section 3583 in the 25 years since the Sentencing Reform Act was passed. But we note that at the time Congress passed it, when it used the phrase reasonably necessary, in other contexts, this court had construed the phrase to be, in the words of Kimmel, a far cry from rational basis review. Indeed, that comports with the express statement in the Senate.
Do you have any indication that Congress was thinking about any of those other statutes you referred to in your brief when it adopted this language?
There's no specific reference to those cases, Your Honor, but two responses. The first is that the Senate report explicitly notes that the goal of supervised release is not to punish. That's what prison is for. Instead, it's to rehabilitate a defender and to ease a defendant.
Which kind of brings me to another point. This restriction is for 3 years. To read your brief, you'd think it was forever, which is it's lifetime for many of these folks who've committed child pornography offenses and are on supervision for life. So, doesn't the time limitation have to be taken into account in the reasonably necessary analysis?
It can be taken into account, Your Honor, absolutely, and you're correct that there are some classes of offenses where lifetime bans are allowed under the statute. But that doesn't obviate the need to look at defendants' liberty. Indeed, Petitioner here is a blogger. He makes his living expressing his opinions in exactly the way that the founders noted.
That's all very good for your side, but on the other hand, his posture at sentencing was defiant and indicating that he was intending to do the same thing further, keep up the fight for the cause he believed in. So didn't that justify the judge in protecting the public with this condition?
That's correct. We do not dispute the government's contention that because of those comments and because Petitioner used a computer in the commission of his crime, some amount of digital restriction is appropriate. But that doesn't mean that a district judge is allowed to ignore the mandate of Section D2 and not consider...
So 1 year would be all right?
I don't think it's the time, Chief Justice Roberts, though certainly 1 year or a 6-month ban would implicate less liberty restrictions. And therefore...
2 years less.
I'm sorry?
It would be 2 years less.
It would be 2 years less, absolutely. And that would make a big difference for a petitioner who, again, spends much of his life...
But don't we leave decisions like that? I mean, here we leave to the discretion of the district judge whether to sentence this person to 6 months or 10 years, right?
Yes.
Why don't we leave to the discretion of the district judge the much less significant question of whether to cut off his computer access for 1 year or 3 years?
The district judge does have ample discretion, but as this court has noted in its post-Booker sentencing decisions, like Rita and Gall, that discretion is only useful insofar as a district judge explains its reasoning and tells an appellate court exactly what it's doing. And that's because, and especially so in the case of Section 3583, Your Honor, Congress gave district judges a scalpel here and not a blunt instrument. They have great leeway to impose special conditions of release that would serve those goals.
At sentencing, other counsel said that he didn't like these conditions, but didn't propose any other suggestions about what kind of limitations might have been reasonable. So what was the district court supposed to do?
Your Honor, counsel below did object to the conditions imposed. Any sentencing briefs are not in the record here, but what we do know is that many courts of appeals have noticed that the need to consider less restrictive alternatives is fairly obvious, that filtering and monitoring solutions, non-technological solutions. Indeed, the Sentencing Commission itself, though it hasn't spoken directly to the case of computer criminals, any consideration they've given to this issue has come in the context of sex offenders.
We've never required any particular language or process by the district court in determining whether conditions of supervised release are reasonably necessary, have we?
There's no magic words, but again, we'd emphasize 2 points, Justice Gibbons. First, this court has not substantively construed this provision of supervised release, though it has looked at terms of incarceration, most notably in Rita and Gall and Kimbrough post-Booker. It has not encountered it in the context of release. But the other thing is, in Gall, this court explicitly noted that it would be an error, a procedural error, to fail to consider the 3553A factors, or, and I'm quoting here, failing to adequately explain the chosen sentence. And that's for several reasons. One of them is that explaining a sentence will promote a dialogue between district courts and courts of appeals and the Sentencing Commission. Indeed, that's why the courts...
Who has the responsibility for initiating the dialogue? Doesn't the defendant's counsel have a little bit of obligation to initiate a dialogue about some restrictions that might be narrower than the one imposed here?
Your Honor, again, I would emphasize that counsel below did in fact object to these restrictions.
There's certainly no indication from the record that he suggested alternatives, is there?
There is no specific indication, though we would note that counsel below noted that it would be very difficult for petitioner to communicate, to exercise his First Amendment rights. I should add quickly that the stipulation that there should be notice is not in the record either. So unfortunately the record is somewhat incomplete here as to what went on below. But what we do know is that the sentencing transcript runs 2 pages. That in response to the very weighty liberty concerns, the district judge's response was that petitioner could continue his blogging by using a typewriter and sending postage stamps.
Well, that was sort of an extreme comment, I think. But if you look at this court hasn't dealt with this issue. The courts of appeal have been struggling with it, but most of the cases are involving sexual abuse and cases. And I don't think there's any case that's dealt with such a computer expert, because this fellow is highly trained. He's shown amazing ability to go through all kinds of places to deliver his message, and so the court really had to struggle with it. And there again, you didn't respond at the time of sentencing with any other suggestion, and even now, you're not suggesting what might be appropriate as a lesser, in your client's situation, what would be appropriate, and still protect the public.
Absolutely. Let me answer the question in 2 parts, Your Honor. The first part is, it's true that most of these cases involve fairly novice computer users who are sex offenders. But there are some cases involving sophisticated users. And most of those cases, in fact, show that this is an extraordinary ban and not an ordinary ban. For instance, the Watt case that we point to in our brief is a case where the defendant was recently sentenced in the District of Massachusetts to 2 years in prison and a 3-year supervised release term involving computer monitoring and not a computer restriction. But in that case, the defendant was the computer coding genius, as a Rolling Stone article described him, in a $171 million
You don't dispute that that when he's actually in prison, he can be deprived of access to his computer, right? He could have gotten 5 years for this crime easily under the guidelines.
He could
correct?
have.
Sure. And so he would be without a computer for 5 years.
Yes.
And what the judge has done here is give him a 1.5 years in prison and 3 years supervised release. If the judge thought it was important to keep him away from the computer, he would have sentenced him to 5 years if you prevail here.
Your Honor, we hope that's not the case, and indeed we think it would be impermissible for the district judge to do so. That's because a decade ago in Johnson against the United States, this court squarely held that supervised release and prison are not interchangeable. Moreover, the district judge here specifically said on the record that any sentence more than 18 months wouldn't do anybody any good. The government has not challenged that term of imprisonment, and nor have we. And so the important...
But that was in the context. He says you don't need to be in jail more than 1.5 years, so long as I know I'm keeping you off the computer for 3 more years. If you go back and tell him he's going to have the computer back, and he said, well, he's going to stay in jail for 5 years then.
But Chief Justice Roberts, we think the point of the congressional tailoring inquiry is that taking a look at less restrictive alternatives would have revealed that the district judge could have furthered those goals of protecting the public and ensuring that no further crime happens, while at the same time providing great benefits to defendants' liberty, which we'd note are very, very strong. There's a cascade of First Amendment interests involved here, from his right to speak and publish and think and associate, and there's employment restrictions that will be crushing. Over 60% of jobs currently require the use of a computer, and there is no exception whatsoever for the probation officer.
But there don't seem to be any perfect software solutions to check up, and the kind of search abilities that the probation office has are limited. And so there again, you go back to the fact that you haven't made any suggestion other than you just think this is no good. But where is the middle ground?
Nothing is perfect, Justice Murphy, that's correct. So let me state clearly what our proposal is. First, there should be some restriction that is reasonable to allow computer and possibly internet use in the context of employment. Many other courts that have looked at that have noted how vital it is to be able to use a computer in today's...
But he's self-employed, so at least he was before he went to prison. So there's nobody that's going to be monitoring at his place of employment. Or would he have to work somewhere else? Would that be another condition?
He might. The government makes the point, and we do not dispute, that it would be permissible for a judge to not allow him to work from home because of the dangers it presents. But that doesn't. But it's a standard condition of supervised release.
Doesn't your concession that there are various conditions that could be imposed on computer use, I mean, once you get to that point, doesn't the standard of review pose some real problems for you in terms of the court's ability to choose which condition it wants to impose?
The district court does have discretion within a range, Justice Gibbons, and that's...
The range can include a prohibition, can it?
Well, we'll note that only 2 cases that the government cites involved a ban this extraordinary and sweeping, and a ban on all digital use and internet use. And in those 2 cases came out of a single circuit, the Fifth Circuit, and we believe that that reasoning should be rejected. There's just too much liberty involved here.
What was the time limit on those restrictions?
The time limit on I believe the Paul case, Your Honor, was a 10-year restriction, and the Craig case, which is an unpublished decision from this year, was a 3-year restriction. And those are the only bans that were complete. Indeed, there are a number of cases. We'll point this court to the Holm case, which is from the Seventh Circuit by Judge Wood, where she noted that a complete ban on a sophisticated user who had spent 30 years in the systems communication industry would simply be too broad.
Well, you know, there are a lot of defendants who've been grateful they weren't sent to prison longer and didn't appeal such a restriction.
Fair enough, Your Honor, but we would hope that this decision would do nothing, a decision in our favor would do nothing to disturb the flexibility that district judges do have.
What was the underlying crime in the case that Judge Wood wrote that you referred to?
That was a sex offense case. That was possession of child pornography, Your Honor.
So, okay. So do you think it's significant at all when you're talking about the employment opportunities here that he used the sophisticated devices to commit the crime? There was a direct connection there.
There is a direct connection, Your Honor. We don't dispute that. But what we do note is that goes to subsection D1 of the statute and not subsection D2. We don't think Congress envisioned a different standard for liberty for sex offenders versus criminals who use computers in the commission of their crime in other ways. There is still a requirement, and has been a requirement for many years, that district judges look and see how a defendant is supposed to, as the Senate report said, ease from prison to liberty, because that's the goal of supervised release. It will be nearly impossible for him to do so with such a crippling and extraordinary ban here. And so, in closing, we would just note that even though we agree there is an abuse of discretion standard, even if this court does not find procedural error, there was an abuse of discretion here because the ban is simply too broad and does not weigh the defendant's liberty properly. Thank you, Your Honor.
Thank you, counsel. We'll now hear from counsel for the respondent. Mr. Denton.
Thank you, Mr. Chief Justice, and may it please the court. I will argue that the evidence obtained in the FBI search was properly admitted, and my co-counsel will argue that the conditions of supervised release were within the reasonable discretion of the district court. This court has made clear that suppression is not a reflexive remedy for any past misconduct, but rather must pay its way with appreciable deterrence of future constitutional violations. As a result, the police error must be both sufficiently culpable that it merits the toll suppression exacts on the administration of justice, and sufficiently deliberate that suppression can meaningfully deter it.
What if Broad knew that Fredrickson had lied once before, and the evidence had been thrown out because of that, and Fredrickson calls again a second time saying, I found this evidence. If Broad says, oh good, and takes it to the magistrate, is that all right, or is that excludable?
I think at that point, Your Honor, we'd have to ask sort of a more factual inquiry about what Agent Broad knew. The fact that Officer Fredrickson...
Agent Broad knew that the last time he dealt with Fredrickson lied about how he got a hold of the evidence. Fredrickson calls again 2 weeks later and he said, you've got another case, here's the evidence I found, in regular police business.
I'm not sure that that would rise to the sort of suspicious circumstances that a reasonable person would not act on without further inquiry. That unless there were some additional circumstances in that
Fredrickson
case,
has lied twice. The last 2 times, Broad said. And the third time, Fredrickson calls and said, I've got more evidence for you. Broad says, fine, let's go to the magistrate. And, at what point does Broad have an obligation to inquire into how Fredrickson got the evidence?
I think at that point, Your Honor, it's a much stronger position that he would. That in Illinois versus Rodriguez, this court talked about the duty to inquire, again, being triggered by circumstances such that a reasonable person would not act without inquiring further.
So there's some duty of inquiry on Broad's behalf.
At some point when the facts that Agent Broad knows convey that duty, then yes, there would be a duty to inquire. In this case, however, there was nothing so suspicious that would indicate that he had such an obligation. Moreover, the reasonableness of his decision not to inquire further is compelled by the fact that the magistrate chose not to conduct any inquiry either when presented with the exact same facts that Agent Broad knew.
Well, this was just like a gift from heaven when he got this call, when Broad got the call, because they could see that how are they going to find anybody from the 2 million, that area? And he gets the call and says, well, gee, I just saw this in the banner in somebody's house on regular police business. Wouldn't it be against Officer Broad's interest to make any inquiry even though he was suspicious? A very tempting situation, wouldn't you admit?
Well, Your Honor, it is a tempting situation. The critical fact that Agent Broad knew, which is relevant on that point, is that the search took place before the crime had been committed. So there's no suggestion that it was a pretextual search or that Officer Fredrickson was in any way searching for evidence of this crime.
It wasn't pretextual. All it did was violate the Fourth Amendment. He didn't have a warrant.
That's correct, Your Honor, and the government conceded below that the search was illegal. But there's a fine line between a Fourth Amendment violation and police conduct so unreasonable that it merits suppression. This court has long held that not every Fourth Amendment violation necessarily merits suppression, that there is some room for officers to have reasonable but mistaken beliefs that what they're doing is appropriate. And we think this is such a case, Your Honor. There's no circumstance that would have suggested to Agent Broad that Officer Fredrickson had acted unconstitutionally, but nor could Officer...
Well, you're focusing on what Agent Broad knew, and your friends on the other side focus, of course, on what Fredrickson knew. And surely there's reasonable basis for Fredrickson to know that his search was illegal.
I'm not sure that's true, Your Honor. I don't think that the circumstances of this search rise to the sort of flagrant violation of the Fourth Amendment that Officer Fredrickson should have known.
Well, but that standard flagrant violation was one that was suggested by a former Ames winner, Judge Friendly, but I didn't think the court had adopted that. We don't ask in deciding whether to apply the exclusionary rule, whether it was a really bad violation of the Constitution or just a run-of-the-mill violation.
That's true, Your Honor. This court has held, however, that suppression is only appropriate if the officers knew or can properly be charged with knowledge that their search violated the Constitution. And
right, because under the theory, they would then be deterred by exclusion.
That's correct. But I think that that leaves some room between any violation of the Fourth Amendment and those where there was a violation of the Fourth Amendment, but the officer could not be charged with the knowledge. In assessing that, it's helpful to look to sort of the guideposts for objective reasonableness in qualified immunity. This court said in Malley versus Briggs that the analysis of objective reasonableness under qualified immunity and under Leon and suppression more generally are coextensive. And so here, we have a case where not only was there no clearly established law saying that a search on these facts was unconstitutional.
You're talking about what Fredrickson knew? It is fairly clearly established law that you don't enter into someone's house without a search warrant.
That's correct, Your Honor. But there's also a wide range of exigent circumstances that this court and the various lower courts have acknowledged, in particular in this sort of community caretaking vein, that officers have wide range of justifications.
What was the community caretaking objective of Officer Fredrickson here?
He had a reasonable, if mistaken, belief that there was a burglary going on, or at least that there was some situation that demanded...
That seems to me to be an exigency. I thought community caretaking was when there wasn't a crime and we were trying to prevent somebody from medical emergency or harm or something else.
Well, I think that the terminology may perhaps be overlapping. In either case, we can say that there was a basis, albeit perhaps a mistaken one, for Officer Fredrickson to believe that there was a burglary.
And what if it's objectively unreasonable?
If it's objectively unreasonable, then the government's in trouble, Your Honor. Okay. And under those circumstances, however, that would...
Well, then maybe we could shift gears a little bit. We've talked about Officer Broad, Agent Broad, and Officer Fredrickson individually. I want to talk about them as a minute for a unit. You sort of made light of the collective responsibility argument that the petitioner made. But it strikes me, two things strike me about it. One, it's supported to some degree in our case law and that of other courts. And second, it is a doctrine that we have applied, although perhaps not calling it that, in other contexts, such as in the context of the obligation to make Brady disclosures. Tell me why it is you dismiss it so quickly.
Well, for two reasons, Your Honor. The first is that the most the collective knowledge rule helps us say is that the affidavit omitted information that was in the collective knowledge of the police. That doesn't go to the question of culpability that this court in Herring said was central to whether suppression was appropriate. And so even concluding that information was omitted...
But it does go to the issue of whether you look at all the knowledge of all the officers.
That's correct, Your Honor. And to the extent that Petitioner argues that we should look to Officer Fredrickson's actions, there's a fair culpability question on him as well, whether his omissions from the affidavit were culpable ones. But that's all that the collective knowledge rule would help answer.
Isn't it particularly appropriate to apply it in this situation where the magistrate did not have complete knowledge, and so therefore you can't really shift the focus of the inquiry to the classic Leon inquiry, which is the reliance on the issuance of the warrant by the neutral and detached magistrate?
Well, I don't think that the collective knowledge rule necessarily takes us out of the Leon situation, because the magistrate had at least two remedies available. Either first to ask for more information, and this was not like some of the cases in which the fact of the prior search was completely omitted from the affidavit. Officer Fredrickson told the magistrate that he had been in the home, where he had seen the information. He appeared before the magistrate to swear to the...
Let's go back to Agent Broad. He said that he would ask questions if there was a red flag. And why wasn't it a red flag when he just got this sort of general statement from Officer Fredrickson that he was on regular police business? That sounds sort of a strange thing to say for a beat cop.
I admit the language may be strange, Your Honor, but I don't think that that gives rise to the sort of indicator of suspicion that would impose a duty of inquiry, that police, as a matter of regular business, do enter people's homes for a wide range of reasons. The mere fact that Officer Fredrickson was in someone's home is not unusual for an officer. That for any individual person, having a police officer in their home may be an unusual circumstance. But for police officers to be in other people's homes is part of their job description.
I think Justice Murphy's question was, the use was a very strange phraseology for a beat cop. You would expect him to say, I was in there pursuing the perp, I was executing a warrant, I was responding to a distress call. Saying I was on regular police business is kind of fishy.
It's admittedly vague. I can't speak to how uncommon that particular...
Well, it sounds like he's patrolling the street. In fact, he's inside somebody's house.
Well, he did say that he was inside the home on regular police business, and he was patrolling the street beforehand. And so, like I said, I cannot speak to the sort of general fishiness of that comment, whether that's a common characterization or not. But I think that the fact that he was in the home and that he characterized it as regular police business are certainly common facts for the police to have done. And in this case, not only did the magistrate have the option of inquiring further of Officer Fredrickson, if the magistrate found the language fishy and found herself in a situation like Petitioner claims where she's just not in a position to evaluate it, the remedy is to deny the warrant.
So what happens if Broad, if you lose this case, and Broad calls back to Fredrickson and says, reads him the Riot Act and says, we lost this very important case because you did this, and we're really upset about it, and, whatever, blah, blah, blah. Fredrickson will be deterred, won't he? The next time he's thinking about going into some house, he'll think, well, the last time I did this, I got in trouble with the FBI. I'm going to go get a warrant, right?
No, Your Honor, I don't think that's true, because for the suppression sort of work its way back to Officer Fredrickson, he would have to have some interest in the use of the evidence, not just now, after the evidence has been found and he's sworn to the affidavit.
You don't think this is a big deal for Officer Fredrickson?
I think it's a huge deal for Officer Fredrickson. It's a national anti-hacking case, and he got to work with the feds, but he didn't know any of that at the time he decided to act. And that's the relevant point at which... It
looks to the future, though, doesn't it? I mean, he's going to be a celebrity because he blew the case. And in the future, once that happens, he'll know, next time I better get a warrant, or this, what happened last time will happen again. The suppression will deter Officer Fredrickson from future violations of the Fourth Amendment, which is why we have the exclusionary rule.
Also cause Broad to ask more questions.
It'll also deter generally, won't it? I think that was 3 at once.
To start at the very beginning, so to speak, I don't think that it will deter, it may deter Officer Fredrickson himself. There's 2 points on that are of concern. The first is that because this use of the evidence was not something that motivated him to act, it's entirely possible that he will find himself in similar situations in the future and say, well, I got read the riot act by the FBI the last time, but there's no way I'm going to find anything that the FBI wants this time. But secondly, there's also a fair concern about over-deterrence in that case, that it will cause Officer Fredrickson to walk away from dangerous situations because he was penalized in this circumstance. And so while officers should obviously have a respect for the Fourth Amendment, they also have an obligation as the police force of our society to protect people. And that's why this court has always recognized the difficulty of decisions on the street and given officers some leeway to make reasonable mistakes.
I don't like the fact, as a judicial officer, that the magistrate is put in the position of authorizing a search based on insufficient evidence or improper material that's provided. Wouldn't it make sense for me to insist that the people who are applying for the warrant, Broad in this case, do a sufficient investigation or face the consequences?
Well,
I don't care whether we're deterring Fredrickson or deterring Broad. I don't want to taint the judicial part of this process by having the magistrate be fooled by the affidavits.
Well, Your Honor, there's already a number of remedies for that, and it's also a bad idea, quite frankly. First, if to the extent that the affidavits filed are misleading the magistrate, Franks versus Delaware still provides a remedy, and there can always be after-the-fact review on those affidavits. But second...
But it has to be pretty bad for Franks to come into play.
That's correct, Your Honor, and I think that's evident in this court's jurisprudence that we're not going to be overly concerned about the technical requirements of a warrant, but we're going to be more concerned about the much higher substantive question about whether the magistrate was actually misled.
You, representing the United States, you don't really want magistrates to be engaging in a more probing investigation of the affidavits your agents submit, right? It seems to me like you're throwing the baby out with the bathwater, or whatever cliche applies. In other words, you're buying into a much bigger problem. Far better to just let this evidence be excluded than to have every magistrate say, I am going to examine whoever's there before me to make sure this problem doesn't come up again.
Well, I don't think it's necessarily going to be that broad a problem. Moreover, I don't think it's that different from the current sort of policy and procedure that any issuance of a warrant necessarily entails two inquiries, which is whether the police have alleged probable cause, and second, whether the police can properly rely on the facts that they've alleged add up to probable cause. And so magistrates are already conducting inquiries into whether the police have justified their reliance on a confidential informant, for example. So while the government might prefer to have less inquiry into its use of confidential informants, that's the context in which Leon was created. And that sort of reliance determination is a familiar one for district judges and is not something that's so unusual. And so in this case, Agent Broad could fairly conclude that the magistrate, knowing where Officer Fredrickson had been and what he had seen there, saw no need to question him any further.
What's the cost of suppression in this case?
It's significant, Your Honor. A guilty man who committed a serious crime will go free. But there's also two sort of secondary systemic costs of suppression. The first is the imposition of this duty of inquiry, a duty of interrogation, essentially, by the feds of local law enforcement officers. And second, a concern about over-deterrence, that Officer Fredrickson and officers in his position will simply walk away from situations that could reasonably present a danger to the public in the future. Thank you.
Thank you, counsel. Ms. C.
Thank you, Mr. Chief Justice, and may it please the court. When a district court finds that a defendant poses little physical threat but a substantial threat online, the court has authority to craft supervised release conditions that both protect the public and respond to that particular defendant and crime. This broad discretion is consistent with this court's overall sentencing jurisprudence in Gall versus United States and Rita versus United States.
But that's broad discretion, but this particular provision seems to require more. It says reasonably necessary.
No, Your Honor. In fact, we can see that when Congress added the words reasonably necessary, it was actually increasing the scope of discretion available to district court judges. We can compare 3583, the supervised release statute, to 3553, which deals with incarceration. There, judges are required to impose a sentence that's sufficient but not greater than necessary. To add the term reasonably necessary to the supervised release statute, a tempering word, would indicate that Congress was intending to increase the flexibility to district court judges.
It is an odd formulation, right? Reasonably necessary. Something's either necessary or not. And I can't tell whether the emphasis is on the reasonably part or on the necessary part.
Perhaps, Your Honor, but even if this court were to look toward the necessary part, that's the same language from the prison statute. And there, this court and all the circuit courts to apply have consistently held that there is broad discretion for sentencing court judges. So even if this court were to rely on the necessary part, there would still be broad discretion.
Well, didn't the district court here sort of have an all or nothing approach? I mean, there's no indication that it considered any halfway measures. I mean, saying that he can rely on the typewriter and the postage stamp was pretty outrageous, considering the defendant before him that had the blog with the 30,000 participants and had pulled off this big, complicated computer thing. I mean, of course, that's what the court was worried about, but still, to cut this person's ability to work, to involve himself in everything that was part of his training, and presumably in prison he would see the light perhaps and cooperate. Why was this not an abuse of discretion?
Well, Your Honor, first, there's no procedural requirement that the judge consider alternatives on the record. But second, all of the factors that the circuit courts have used when they uphold and reject similar supervised release conditions indicate that this is a reasonable condition in this case.
Well, many of those cases, though, do not involve an individual who uses computers as his normal work, correct?
Well, Your Honor, that is true in several of the cases, but that doesn't change.
And they also don't involve individuals whose education and experience are all, as far as we know, in that area.
Not necessarily, Your Honor. For example, in the Second Circuit case of United States versus Johnson, an unconditional ban was upheld, and there the defendant was a sophisticated user who was trained as an aerospace engineer.
So there's some, but many of these cases that the parties have referred to don't involve that kind of situation, right?
That is true, Your Honor.
So in some ways, the burden on this defendant is far greater than the burden on many others, right?
Perhaps, Your Honor, it does foreclose some job options available to this defendant, but that isn't dispositive because the district court judge reasonably found that this condition was necessary to protect the public.
Well, given the extent of the harm, wouldn't it make sense to require some articulation of the reason for the complete and total ban?
Well, no, Your Honor. Again, there's no procedural requirement to consider all those reasons.
But shouldn't there be?
No, Your Honor, there need not be a procedural requirement to consider that. It's unnecessary, and it would be an unworkable rule if this court were to require that.
Well,
How are we... I'm sorry.
Wouldn't it be similar to the district judge has to, in the sentencing, not committing a procedural error? Shouldn't, like the district judge does in sentencing, have to go over the different factors and show that they've been looked at?
Well, yes, Your Honor, and that occurred in this case. The district court judge did say with reference to the appropriate factors he was imposing the sentence. But when this court talked about significant procedural error that warrants remand in Gall, it was talking about the sort of errors that are clearly required by the statute or by this court's jurisprudence.
This judge told us nothing about why 3 years was required rather than 3 months. And without an explanation of how he has tailored the supervised release requirement to the particular crime or the particular defendant, we have nothing to review. We can't tell. How can we tell whether this is reasonably necessary if he hasn't explained to us why he chose 3 years instead of 5 or 1?
Well, Your Honor, this court can look towards the same basis that it articulated in Rita. It's enough if the judge indicates that he considered the arguments before him and if there's a reasoned basis in the record to support the sentence. And that's what exists here. We can look towards the record and find that the characteristics of this defendant and of this offense indicate that this is an appropriate supervised release condition.
What if the judge has a rule? Every case that involves a computer that comes up before him, you get 3 years off the computer.
If the judge had that rule and this court were reviewing it, Your Honor, we might have reason to be suspect about the record, but that wouldn't be an indication to impose a new procedural requirement, because again, there it would be enough for this court to review it, to look at the record and see whether that was a reasonable conclusion in the particular factors of that case.
Well, you'd have to agree that there's no effort in that case to carefully tailor the provision to the defendant, right? It's an absolute rule. Okay. And you agree, I take it, that there is a requirement of tailoring the condition to the particular defendant?
Yes, Your Honor. There's always tailoring required in the sentencing context. This court has said in Gall and in Kuhn that sentencing judges must look at the particular defendants and crime before them.
And you agree that since the statutory language is reasonably necessary, that tailoring has to be fairly rigorous?
Well, no, Your Honor. We would say that Petitioner is importing this court's jurisprudence from other areas of law, which is simply inappropriate in this context. This court has been very clear that when we are dealing with offenders who are on conditional release, there's a very different standard that applies. In Griffin and Morrissey and Pennsylvania Board of Parole versus Scott, this court has said that offenders on conditional release do not have the same scope of constitutional liberties as a regular citizen. In fact, this court rejected the same methodology Petitioner is advancing here in McCune versus Lyle. There, the defendant, despite his seemingly impressive array of authority about liberty restrictions, his argument was unavailing, and this court said it was because he treated the fact of his incarceration and his felony conviction as irrelevant. This court simply does not import the same strict standards of scrutiny that would apply to a liberty restriction on a regular member of the public.
You know, the judge gave the defendant a really good deal as far as the time in prison. Do you think this goes, again, because the record is so incomplete, do you think this judge didn't understand what a terrible deprivation this would be to this individual, to have this extreme condition of supervised release?
No, Your Honor, there is no indication of that. Again, the judge listened to the arguments that were before him, and defense counsel raised those, and the judge denied his motion for reconsideration. Again, that's what this court has required in Rita. The way to analyze...
If the defense counsel had suggested specific alternatives on the record, would the district court then have had to articulate his reasons for selecting this particular condition?
Perhaps, Your Honor, because again in Rita...
So is this a case not about whether there's a requirement to articulate a reason, but about whether defense counsel raised the issues they needed to raise?
Well, Your Honor, that would make it a different case. But here, this case is about whether the record supports that this is a reasonable restriction, and it does. All of the factors that the circuits have looked towards, again, when they're upholding and striking down these conditions, indicate that this was a reasonable conclusion and certainly not outside the range of the judge's discretion.
Why isn't it more reasonable to simply require monitoring the various programs that will make sure he doesn't do anything bad with his computer, but still allow him to, have contact with the outside world?
Well, yes, Your Honor, simply because those monitoring alternatives would not be effective for this type of defendant or this type of crime. Even the courts who have required district court judges to look at alternatives have noted that they would not be effective when there's a sophisticated computer user because they're able to evade technological forms of monitoring. Petitioner today argues for an employment exception, sort of a non-technological alternative, but as the Second Circuit noted in Johnson, that's not appropriate when you're not dealing with something such as child pornography where you're concerned about telltale images on a screen. Johnson said it's very different when you're even just concerned about chats and email logs, much more here when we're concerned about computer hacking. That's not something that casual monitoring by coworkers or an employer is going to be able to check. So this is simply not a case where technological or non-technological alternatives would be effective. At the point,
isn't it sort of a blind thing? There's some kind of taxes that I have to pay. I can only pay, according to the state of Minnesota, by the internet. I mean, there's so many different, it's not just the government, but there are many kinds of transactions that you want to make as an ordinary citizen. And of course, your obligations to the government should be of interest to you. Isn't this a complete lack of understanding? I mean, he could be required to go to the library to make these transactions or something. He wouldn't be able to hack into everything there. I mean, it's just such a broad brush.
Well, Your Honor, it is true that this condition will make some day-to-day activities more difficult for the defendant. There's no reason in the specific example that Your Honor gave why the defendant couldn't have a friend or family member file the taxes for him. But simply because the internet restriction impacts day-to-day activities does not make it impermissible. In fact, the pervasiveness of the internet is one of the reasons why this crime is particularly dangerous. As several of the circuits have noted, such as Zinn and Vogler, the anonymity and pervasiveness of the internet have created new types of crime that require judges to be flexible.
Does there have to be a connection between the underlying crime and the use of the computer? I mean, let's say you have a defendant who's convicted of a particular financial fraud that he did not use the internet or the computer to execute. But the judge is worried. He says, well, maybe he will. It would give greater scope to his crime if he did use it. So he can't use it for 3 years. Is that a problem?
Well, Your Honor, there are different ways that the computer can be used in a crime. The computer can be an instrumentality of the crime. It can be something that's illegal because it occurs online, even if someone else engages.
You can do a lot more damage in almost any area if you have a computer, right?
Yes, Your Honor, that's
So
true.
a judge can say, I don't care what your crime is, it's going to be worse with a computer, so no computer for any criminal for 3 years.
Well, no, Your Honor. There it would fail because it wouldn't be reasonably related to the factors in 3583. There it wouldn't be related to the nature and circumstances of the
Well,
offense.
but see there, I mean, you just, reasonably related might be a test that would be more agreeable to you, but the statute says reasonably necessary.
Yes, Your Honor, I'm sorry. The reasonably necessary prong applies towards protecting the public and deterrence. The reasonably related to the nature and circumstances of the offense is in 3583C, which talks about reasonably related. So that's not under the reasonably necessary prong.
How can this have been necessary when there's no indication that this defendant is likely to reoffend? I mean, he's gotten 18 months in prison for something that was, from his point of view, a prank. We think he's not going to be deterred?
Well, Your Honor, the district court judge did find at the sentencing hearing that this defendant was likely to reoffend.
What was that based on?
The district court judge specifically pointed to his statements at sentencing, where he said that he was just standing up for what he thought was right and acting for the best interest of all of us.
Well, that would be, by the way of explanation of why he committed the crime, not by way of saying he was going to do it again.
Perhaps, Your Honor, but this district court judge did find that this defendant was likely to reoffend. He found that he paid only lip service to the rule of law. In Gall, this court has said it's important to defer to district court judges for this very reason, because they have access to the full scope of the record. They make credibility determinations, they hear all of the evidence before them. They're also able, importantly, to rely on insights that are not conveyed by the record, which would not be available to an appellate court.
Well, how much does that apply? I mean, we haven't seen all these extreme supervised release conditions yet. So why do we necessarily apply the rules of Gall?
Your Honor, we would apply the rules of Gall because this is part of sentencing overall. When Congress enacted 3583, it talks about supervised release as part of sentencing. So this court's overall sentencing...
Well, isn't Gall backward looking at what's happened before, and supervised release is looking out into the future, and we're trying to reform the defendant? Get them back into the regular parts of life.
It is true that one of the purposes of supervised release is to help the defendant be reintegrated into society. That's not the only purpose of supervised release, however. In Griffin, when this court talks about conditional release, it says that there are dual purposes, both to help the defendant transition, but also to provide a safe environment for the public during that process. So it's necessary that supervised release conditions do help protect the public. Also, the circuits who have looked toward the rehabilitation have noted that by removing a defendant from the instrumentality of the offense, that does serve rehabilitative goals by setting the defendant up to succeed when he transitions back to society.
You agree, don't you, that the district court has less flexibility in imposing conditions of supervised release than it does in imposing sentence?
No, Your Honor. Our position...
Well, is it only the supervised release part that talks about being reasonably necessary?
Yes, Your Honor. Again, our position is reasonably necessary implies more of a range for a sentencing court judge than simply the unqualified necessary language in the prison term. So there would be the same broad discretion that would apply. It's necessary to have a rule that gives district court judges the flexibility they need to protect the public and to deter reoffense, and to do that based on the factors in the record before them. This district court judge had a defendant who was a sophisticated computer user, where alternative technological and non-technological means of monitoring would not be effective. The district court judge also...
So if the crime was making obscene phone calls, the judge could impose a condition of supervised release that the defendant not use the telephone for 3 years?
Well, Your Honor, that would be a harder question. Here we would say most likely not, because the need to protect the public would not be as great. This case, we have a crime that the defendant committed that caused over $1 million in damage, that eviscerated the value of many of the small businesses on the Ames Stock Exchange, that caused a national panic. This is a crime where the need to protect the public is particularly strong. We also have a crime here where the defendant not only used the computer to commit the offense, but there's outward use of the computer, which, as the D.C. Circuit noted earlier this year in United States versus Love, there's an emerging consensus among the circuits that computer and internet restrictions are appropriate where the defendant uses those to commit new and direct harms in society, which is exactly what we have in this case. There's also an additional element in this case because it's not simply using the computer to facilitate something that was illegal on its own. The crime itself is defined in terms of hacking into a protected computer system. The crime is disrupting the computer system itself and is only possible because of the technology the defendant used.
Well, the monitoring systems they can place on the computer, while they may not have the entirely prophylactic effect, they certainly make it easy to identify where the problem's coming from, right? He will know that whatever he does in the future on the computer, he'll be singled out right away.
Yes, Your Honor, there would be that effect. However, in order to monitor, it would be necessary to have a probation officer who's as technologically savvy, if not more than the defendant, to tell what kind of code provisions are malignant and what's a legal use of the computer. So it would not be outside the realm of the district court judge's discretion to find that it's unnecessary to have that sort of condition. Here, the district court judge reasonably looked at the circumstances of this defendant before him, a sophisticated user who the district court judge specifically found was likely to reoffend.
Well, in addition to the software, they can get the defendant to agree that he can be subject to search at any time. They can search his hard drives, his computer at any time. Isn't that a good deterrent?
Yes, Your Honor, may I finish this question? That would not be a good deterrent because that's not the right type of crime here. Hard drive searches might be appropriate when we're dealing with something like child pornography possession. Here we're dealing with outbound use of the computer, real-time computer crimes, which the courts in Johnson and Freeman noted are much harder to detect. So that would not be an appropriate condition.
Thank you, counsel.
Thank you, Your Honor.
Mr. Harrell, you have rebuttal?
Yes. Your Honors, a couple of brief points on each issue. First, this court rightly seemed concerned during the government's argument about the scope of the rule that the government proposes. Chief Justice Roberts, you pointed out that Officer Fredrickson certainly should have known his conduct was unconstitutional, considering it was a warrantless search of Petitioner's home. The government denied that this was true, relying on the fact that this court hasn't spoken explicitly to this issue. But if that's the rule, if the rule is that the good faith exception would apply unless the court has explicitly spoken to the issue, imagine what the training of officers would look like in that world. Police departments would train their officers to only observe Fourth Amendment requirements where this court has unambiguously spoken to that issue, but this court has already rejected that approach. In Johnson, another Johnson case from 1982, this one on retroactivity, this court noted that in close cases, law enforcement officials would have little incentive to err on the side of constitutional behavior unless this court deterred up to the limits of the Fourth Amendment instead of essentially equating it with the qualified immunity rule. Second, as to the role of magistrates, this court was concerned with whether magistrates can and do pass on the constitutionality of prior searches that lead to warrant affidavits. And that's because in practice they don't. Warrant proceedings are hasty and ex parte, as this court noted in Franks, and that's why no circuit court has adopted the rule that the government proposes. Indeed, the case... Well,
if you prevail, they sure won't be, right? They'll become very extended criminal inquiries. The magistrate's going to have to pick apart every line in the affidavit.
Absolutely, Your Honor. And we'd note that that would run up against some serious tension in this court's few cases dealing with the constitutionality of magistrates where it noted that magistrates can actually be non-lawyers. And so because probable cause determinations are fairly common sense inquiries, it is appropriate to let magistrates fill that role. But where they would have to, exactly right, Chief Justice Roberts, undertake a detailed inquiry, that wouldn't be appropriate for the current individuals who are in that role, especially in state court proceedings. Moving on to the supervised release conditions, Your Honor, a few points. Chief Justice Roberts, you noted that it's hard to tell whether Congress put the emphasis on the reasonably part of the statute or the necessary part. But the key difference in 3553 is neither reasonably nor necessarily, but liberty. That's a difference in 3583 and in supervised release that really creates the distinction here. And it's essentially the government's rule reads out the need to consider a defendant's liberty. Indeed, my friend Ms. C repeatedly said that there are no procedural requirements.
I mean, I think the rhetoric's getting a little out of hand. I think many of us thought we were free before we even knew about computers and all this sort of stuff. It's not critical to liberty that you have access to the internet.
It's critical in many ways, Your Honor, to Petitioner's liberty. He is a blogger. He is a computer science graduate. Indeed, even retraining him to get another job would be exceedingly difficult without...
But that's the problem. That's not the answer. I mean, if you have a school teacher who's convicted of indecent liberties with students, do you say, well, you can't keep him from school, that's his job? Of course not. There's a direct connection between the computer and the crime. Saying, well, he needs the computer, I mean, he's good at the computer, and that's why he was good at committing the crime, and that's why you shouldn't let him do it for at least 3 years.
Absolutely, Your Honor, but that's exactly why looking at alternative solutions would provide the benefits that Congress was worried about in terms of examining the impact on liberty, while also serving substantially deterrent and protection of the public goals. That's what Congress created with this statute. It said that district judges must strike a balance. I see my time has expired, Your Honor.
Thank you, counsel. The case is submitted.
The court is now in recess. All rise. Please be seated.
Well, what a great evening. First of all, I want to say what a great honor it is for me to be sharing the bench with two such distinguished jurists. Diana Murphy is a past winner of the Devitt Award. The Devitt Award for federal judges, it's the Nobel Prize for the federal judges. It's a coveted award and very well deserved in Judge Murphy's case. Julia Gibbons works with me on the Judicial Conference. She's head of the Budget Committee, which means she's got to get, how much is it? $7 billion. $7 billion. $7 billion out of Congress every year. Our new motto is that the federal judiciary is too big to fail. That's our... And it's a thrill for me to be here, back at Harvard for an Ames final. I decided very early in my first semester that I wanted to participate in an Ames final. And I decided the easier way would be to get appointed Chief Justice and come back as a judge than to do what you all have had to do. We were very, very impressed by the briefs and by the advocates in a number of particular ways. Mr. Mayor, I thought when your response when I asked you about what the court's beautifully written opinion in Herring meant to get language from the same opinion that supported you and turn it back was just a wonderful way to turn a question around. Very, very effective. Mr. Harrell, I thought you did a wonderful job of controlling the argument, which is very, very hard for a lawyer to do. You did a number of ways, but one in particular, when you had a response, you would say like you had 2 points, which not always, but often causes the judge to pause and let you get to the second point. And you did that. Sometimes the judge will cut you off anyway, but it's a good way to try to control the argument, and I thought you did very well in the rebuttal. Mr. Denton, a couple of things that really struck me that were very well done. You got into a little exchange with Judge Gibbons about exigent circumstances or community care, which I think you quickly decided that it didn't matter. And it was sometimes an advocate can't resist being dragged into a detour, and it wouldn't have made a bit of difference to your case whether it was exigent circumstances or community care. So you quite quickly moved off that, and I also found effective, although awfully risky at this stage. I mean, I at one point referred to some fishiness about something. And you responded, it's sort of like with scare quotes around it, saying, well, you know, I forget what it was, you know, however fishy that might seem. But it was done beautifully, just enough that a little bit more intonation in your voice and it would have been offensive, but no, I don't mean that facetiously at all. It wasn't, and instead it was very effective. I mean, the point that I was trying to make about sorts of, fishiness, something seems not quite right, you had a way of responding to it, which is more or less you don't have anything more concrete than that, which I thought very, very effective. Ms. C., I was very impressed when you were talking about something being reasonably related, and I pressed you on whether or not it was, in fact, reasonably necessary, and you quite correctly came back and said, you know, you're referring to a part of the statute, and that I was talking about the wrong section. I was just testing you. I knew what. But it's very important and very difficult for advocates to know that. I mean, it doesn't matter who you're talking to, and when they say something that's wrong and contrary to your client's interest, you have to stand up very quickly and correct it. And you did that extremely well. And I also thought it was quite wise of you not to dispute the fact that some tailoring was required. That would have been a losing position, and instead you agreed that it was and then went on to explain why it was adequately done in your case. So in every instance, I was just very impressed with some of the skills brought to bear. I don't know if you have anything to add on those points?
Well, we could go on at length, but I think you summed it up very well.
Okay. So decisions. I will say it's very difficult for us. It's not always the case when we do these moot courts, but we found the choices here hard ones to make. And certainly all of the advocates should be congratulated, all the folks who worked on the briefs and helped prepare their team members. It was a very good presentation all around. But we had decisions to make, and we did. We thought the best brief goes to the petitioners. They did a very good job in the brief. We thought Mr. Denton was the best oralist. And as you might imagine, given that division, it was a very difficult call on the best overall team, but we decided that that title goes to the petitioners.
The court is adjourned. Have a good night.